Hello, my dear students. Today, under labor law first paper, we'll talk about the concepts of a strike and lockout and gherao. This is video lecture number 30. And under Industrial Disputes Act 1947, we'll talk about the strike and lockout and gherao. The law gives room for strikes and lockouts to take place in industries on condition that they are peaceful, causing no harm to the society and no vandalism to public or industrial property. So law permits for the strikes and lockouts under Industrial Disputes Act 1947, and law gives room for strikes and lockouts to take place in industries on condition that these lockouts and strikes should be peaceful and causing no harm to the society and no vandalism to public or industrial property. Under section 2Q, strike is given, and strike is one of the oldest and the most effective weapon of labor in its struggle with capital for securing economic justice. So employees or the workmen, they use strike as a weapon available to force for their demands to the employer. And the basic strength of a strike lies in the laborer's privilege to quit work and thus brings a forced readjustment of conditions of employment. It owes its origin to Old English words striken, to go. In common parlance, it means hit, impress, occur to quit work on a trade dispute. The term strike has been defined in a wide variety of branches of human knowledge in etymology, sociology, political economy, law, and political science. A strike has been defined in Section 2Q of the Industrial Disputes Act. Strikes means a cessation of work by a body of persons employed in any industry acting in combination or a concerted refusal or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. So, a strike means a cessation of work by a body of persons employed in any industry acting in combination or a concerted refusal or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. The analysis of definition would show that there are the following essential requirements for the existence of a strike. Number one, there must be cessation of work. And the cessation of work must be by a body of persons employed in any industry. And the strikers must have been acting in combination. And the strikers must be working in any establishment which can be called industry within the meaning of section 2J. And there must be concerted refusal. And refusal under a common understanding of any number of members who are or have been so employed to continue to work for or to accept employment. And they must stop work for some demands relating to employment, non-employment, or the terms of employment or the conditions of labor of the workmen. My dear students, now we talk about the ingredients of the strike. So the first ingredient for strike is the cessation of work. This is the most significant characteristics of the concept of a strike. It has been variedly expressed as abandonment, stoppage, omission of performance of duties of their post, hampering or reducing normal works, hindrance to the working or suspension of work, discontinuing the employment or breaking their contract of service, or refusing or failing to return to or resume employment, or refusing or failing to accept engagement for any work which they are usually employed for. Thus, what required for strike is that there must be stoppage of work, or there must be refusal to continue to work or to accept employment by any number of persons employed for the work, but the refusal must be concerted or under a common understanding. The cessation of work may take any form. It must, however, be temporary and not forever, and it must be voluntary. No duration can be fixed for this. If the cessation of work is as a result of renunciation of work or relinquishment of the striker's status or relationship, it is not a strike. So no duration can be fixed for the strike, and if the cessation of work is as a result of renunciation of work or relinquishment of the striker's status, then it is not a strike. Permanent cessation of work, permanent cessation of work would result in termination of the contract of work. So permanent cessation of work would result in termination of the contract of work, which is alien to the underlying sanction of a strike, retaining contractual relationship during the strike periods. Cessation of work is not a cessation of contract of employment actually. And concerted action, the other uh, what we call the ingredient of this strike is, the first one we have gone through, the cessation of work, and the other one is the concerted action. Another important ingredient of this strike is a concerted action. The workers must act under a common understanding. The cessation of work by a body of persons employed in an industry in combination is a strike. Thus, in a strike, it must be proved that there was cessation of work or stoppage of work under a common understanding, or it was concerted action of the workers, or there was a cessation of work by workers acting in combination. Stoppage of work by workers individually does not amount to strike. The concerted refusal or refusal under a common understanding to continue to work or to accept employment or to resume work by any number of persons is a strike. One thing must be kept in mind, that the refusal of work means refusal to perform duties which the workers are required to perform. If the workers are at liberty to do a particular work or not to do a work, their refusal to work does not amount to strike. For example, overtime work, if it is the duty of the workers to do overtime work necessarily, because it is the practice of that establishment to take overtime work from the workers, in that case, refusal to work overtime would amount to strike, otherwise not. Thus, the test to determine whether refusal to do overtime work constitutes a strike or not would depend upon whether overtime was habitually worked in that industry or not. And when a strike becomes illegal, if it is in breach of contract of employment, if it is in public utility services and no notice has been served under section 22 subsection 1, and if commenced during award or settlement period, in all those cases strike would be treated as illegal one. And if the strike commenced during or within 7 days of completion of conciliation proceedings, then it also becomes the illegal. And if commenced during or within 2 months of the completion of the adjudication proceedings, then it is also the illegal. So these are certain things, the important concepts about the strike, that what is a strike, how a strike would be treated as an illegal strike, and what are the essential ingredients for the strike. Now we talk about the lockout. The lockout, as defined under Industrial Dispute Act, the use of the term lockout to describe employer's instrument as economic caution dates back and is younger than its counterparts in hands of workers. Strike by 100 years. Formerly, the instrument of lockout was resorted to by an employer or a group of employers to ban union membership. The employers refused employment to workers who did not sign a pledge not to belong to trade union. Later, the lockout was declared generally by a body of employers against a strike at a particular work by closing all factories until strikers return to work. So when lockout is legal, the act treats strike and lockout on the same basis. It treats one as the counterpart of the other. As there is a case, Muhammad Samsuddin, the circumstance in which the legislature has banned strike, it has also at the same time banned the lockout. Thus, what holds good, bad, illegal, legal, justified, unjustified for strikes holds the same for the lockout, because lockout and strike are the counterparts. We treat strike and lockout as a counterpart. As such, the provisions of the act which prohibit the strike also prohibits the lockout. The object and reasons for which the lockout are banned or prohibited are the same for which the strikes are banned or prohibited. It is because the employer and the employees are not discriminated in their respective rights in the field of industrial relationship between the two. Section 12 of the Industrial Dispute Act 1947 defines lockout: the temporary closing of employment or the suspension of work or the refusal of an employer to continue to employ any number of persons employed by him. As delineation of the nature of this weapon of industrial warfare required description of the act which constituted, the party who uses it and the party against whom it is directed, and to motive and the motive which prompts resort to it. So this is what all about the lockout. Now we will just have a look of that what is the meaning of gherao. So, and what is the object of gherao? The main object of gherao is to inflict physical and mental torture to the person being gheraoed, and hence this weapon disturbs the industrial peace to the great extent. I repeat, my dear students, that the main object of the gherao is to inflict physical and mental torture to the persons being gheraoed, and hence this weapon disturbs the industrial peace to a great extent. Gherao meaning is enrichment is a word which denotes a tactic used by the labor activists and union leaders in India. It is similar to picketing. Usually, a group of people would surround a politician or a government building until their demands are met and or answers given. This principle was introduced as a formal means of protest in the labor sector by Subodh Banerjee, the PWD and Labor Minister in 1967 and 1969 United Front governments of West Bengal, respectively. So this is all about the Gherao, my dear students. Thank you so much for your patience listening, and I believe today's lecture will make you comprehend about the concept of a strike and lockout and Gherao. So uh, we have gone through the definition part of the strike and the when a strike would be treated as illegal, and definition of the lockout, and when a lockout would be treated as legal, and what is the meaning of Gherao. So I believe this lecture will help you, my dear students. Thank you so much. And in our next lecture, we'll take up some new topic of the under Industrial Disputes Act 1947. Thank you so much. Have a nice day. Have a nice time. Thank you. Bye bye and take care.